Good morning, everyone. Welcome to day 2 of MSO's 13th Annual Educational Seminar. Welcome back. Thanks again to all of our attendees, presenters, and sponsors. I'm a lot happier now than I was an hour ago. Our next presentation is from Rick Gallin of Methfessel Werbel. Rick is going to be talking to us about first-party property claims. His bio is in the program. Rick, take it away.
Scary thought. Good morning. You know, a judge once said to me, he says, Gallin, every time you're here, every case you ever bring in front of me, your insurance company has denied coverage. And I'm thinking to myself, well, of course, Judge, I'm only here on cases that are litigated. You don't hear about the 95% of the claims that get resolved without attorney involvement. In this presentation, I made some notes. I don't know how long it's going to go, but I'm going to cover some few general principles, things that we see in litigation cases. And I got some cases that I've worked on over the years, which I'll go over. You know, I used to think lawyers tell war stories just because they like to sit around a bar and tell war stories. But I realized that half the reason why lawyers tell war stories is it's a way of passing knowledge down. That I give examples of what I've gone through. Maybe you have something similar. Maybe it gives you an idea on one of your cases. It can be a learning exercise. And we all know that most claims get resolved without issue. The claims that I see are the claims where there's red flags. You know, sometimes a red flag can be obvious. Sometimes it develops over time. Sometimes a claim just doesn't look right or doesn't smell right, and you start digging and you start finding more and more red flags. And those are the claims that get referred to SIU. Those are the claims that get referred to defense counsel. Those are the ones that become the problem childs. And before I get too far into the problem childs, just one observation. I know when we adjust losses, first party claims, we try and do them with mathematical certainty. We get an inventory list, we get an ACV, we get an RCV, we get a builder. We try and get some sort of certainty as to what the claim should go for. What I can say on problem child cases, and I've had this conversation with insurance companies, is, you know what? Forget the adjustment. We've been litigating this case for 3 years. Forget what the actual number should be. Sometimes claims just have to go away. Some cases just become problem childs. And sometimes you pay a little bit more than you would have done. But the problem child cases are the ones sometimes they're a little harder to resolve, and sometimes you got to put aside mathematical certainty and just treat it as an art form and not a science to resolve the claim. Now, a lot of the claims that ultimately come down to the clause in the policy, you don't pay claims when there's concealment, fraud, or misrepresentation. And those are a lot of the issues you're dealing with. These issues can come up on the application. They can also come up on the claim process. They can come up on the way the claim is described to you, and it can come up in the way the damages are claimed or what damages are being claimed. And we're not talking about the average case where your adjuster says $500,000 and the public adjuster comes in for $1 million. That doesn't quite reach the level of the fraud we're talking about. Those are like reasonable differences, but sometimes the claim damages are just so excessive. Total red flags. You have a 2-bedroom apartment. They're claiming a theft claim. And all of a sudden, what gets stolen? 5 big screen color TVs, all purchased with cash, all within the last 6 months, and nobody has a receipt. That's a red flag that there's something going on, that maybe this 2-bedroom apartment didn't have 5 big screen TVs, especially when the guy was living there by himself. Let's talk about applications for a second. So what are you going to look at in an application? So the first question is, who filled it out? And there's a difference. I assume a lot of you with the MSO, you're not dealing with captive agents. You're not State Farm, you're not Allstate, you don't have in-house agents. When there's a captive agent, the agent is always working on behalf of the insurance company. If there's a misrep in the application or the agent does something wrong, that is going to be binding on the insurance company. It is not the same thing when you deal with independent agents. Independent agents wear two hats. They can have binding authority, and they can bind a company by issuing a binder on a policy. And that's one of the cases I'm going to discuss later on, even though they didn't actually have the authority to do that. And that's a situation when the insurance company can have a problem and be stuck with a policy they didn't want. But when the agent is presenting a risk to an insurance company, especially when they don't have binding authority, they're filling out the application and submitting it to underwriting, they are actually acting on behalf of the insured. And an insured will say, well, I didn't tell my agent to do that, but they're still acting as the agent on behalf of the insured. And a misrepresentation can come back against the insured, even if they didn't personally make it and it was submitted by the agent. So when you're looking at the application or application, misrepresentations, figure out what are the circumstances under which the application was done. A lot of times the insured will say, well, I didn't sign it. But if it was submitted by the agent, put on the agent by the agent on your website, that's still an act of the insured. So what happens when a claim comes in? A lot of you are, assign it to independent agency. Some of you may have your own field agents, or you may have, a lot of you are going to be using independent agents. That's your first line of defense in picking up red flags. What's the field adjuster going to do? They're going to go to the scene. They're going to try and figure out what happened. They're going to take a story from the insured. A lot of these guys are very experienced. And if there's a problem, they're going to start picking up. They're going to notify you. Hey, there's a problem here. Something doesn't add up right. I had one recently where the insured claimed that his air conditioning system leaked and caused a $25,000 or $50,000 water loss. Except there was a $5,000 limitation in the policy for backup of sewer and water. He had an incentive, and his plumber was going to come out and say the water leak. But the adjuster got very suspicious about it, especially when the pictures were showing brown water, not clear water. It also didn't help that the wife kind of said, oh, are you here about the flooding claim? Apparently the wife was not supposed to speak to the field adjuster. What do? They get an engineer who goes out there and says, no way, there's nothing wrong with the air conditioning system. This didn't come here. And that's actually a case, total red flag. We know what was going on, got sent to me. I sent out an EUO notice. I get a call from the lawyer. We're looking at this. We're not so sure. So we ended up resolving the claim for the $5,000 sublimit for the backup of water and sewer. So you're going to pick up things in the field early on. I'm going to take a little, throughout this thing, and there's a couple of side ways I'm going to go. And one of them is subrogation. A lot of companies say, well, worry about subrogation when the first party claim is resolved. The horse has left the barn but a year later when you've settled the claim. We, along with a lot of the other companies that do other firms that do subrogation, spend a lot of time trying to convince insurance companies, if you got something that may be viable subrogation, let us know from day one. On a subrogation case, you got to start your investigation from day one. You got to figure out who your targets are. You got to get your experts at the scene. Your experts have to see the scene. A lot of times, if the fire, we're going to do a field investigation. The experts all get together. It's kind of interesting when you go to these subrogation cases, field exams. First of all, it's a limited number of investigators, so I always have to show up and say, who's on my team today? Oh, I can't talk to you today, but when we have a break, let me talk to you about the other case. I had one of these where expert was there for my adversary, except one of his partners was doing a scene exam for me in a different state, and an emergency came up. So I had to go up to the expert and say, I need to get a hold of your partner. The lawyer starts yelling at me, saying, why are you talking to my expert? I said, we're not talking about your case, but I need him to get a hold of his guy so we can discuss the case where he's working for me. You don't want to have spoliation issues on subrogation. You want to collect the evidence. You want to get it to storage. Once the evidence is collected and it's in storage, then you can take your time, finish your first party adjustment. But you've already got your theories lined up, your evidence preserved, and you can get a lot of money back on subrogation. One caveat, be careful on lower value cases and products liability cases. I'm not going to mention any companies, but it has something to do with, I'm sure a few of you had fire cases involving ceiling fans and bathroom fans from a company we're not going to name. They take a very tough line. You got a big case, you can get recovery from them, but it doesn't pay to fight a subrogation, do a products liability subrogation case if you're talking $15,000, $20,000, $25,000 worth of damages. There's not enough recovery there. Okay, once you start figuring out potential problems, I get calls saying, we want you to do an EUO. So then we got to talk about it. Why do you need the EUO? A lot of times, your field investigation has developed enough information that you know which way to go without doing the EUO. As soon as I send out an EUO notice, they're going to lawyer up. I'm seeing the property claims poll 1. Not for me to answer. So I tell companies, you have a statement from the insured. You have a recorded statement. You really have enough to go on. If you're going to deny the claim, let's just deny the claim. Sometimes the EUO can be really valuable. Maybe you don't have enough information. You can get more investigation through the EUO. And sometimes the EUO is taken just to send a message. And the message is, we know this is a screwy claim. Let's sit down. I'm going to go over it with you in front of the public adjuster, show you what we got, and you really want to press it. I had one of those claims where the property was vacant for months. It was a restaurant up in the Catskills, and they were snowbirds, so the restaurant was closed up. And obviously, they had a water loss, and the timing of it made no sense. You looked at the water bills, and the water usage totally spikes in February, meaning that's when the pipe broke. And they're claiming this happened in April, and they'd actually cleaned up the property before they gave the insurance company notice of the claim 2 months later. And we had all this good evidence that these people simply were not telling the truth about what happened here. So I went through it, went through the pictures, I went through the utility records. And when it was over, the public adjuster and I had a little chat, and that was kind of the end of the claim. That's an example of an EUO, not so much to get investigation, but to share information that this is not a claim you want to go forward on. The next 2 points I'm going to make are some of the personal issues I've had with insurance claims departments over the year. And the first one is issuing the disclaimer. Please do not ask me to sign the disclaimer letter. Insurance companies say, well, you're a lawyer, you write the disclaimer letter and you sign it. I'll ghost it for you. But there's very specific reasons. Do not ask your lawyers to sign the disclaimer letter. Once the lawyer signs the disclaimer letter, he has become part of the claims process. He's involved in actually making the claims decisions. The lawyer is now a witness to why the claims decision was made. Once the lawyer becomes a witness, he can't be your lawyer anymore. Secondly, if the lawyer is actually actively involved in the claims process, excuse me, you lose the attorney-client privilege. And there's cases out there where insurance companies have been forced to turn over the lawyer's reports because he was involved in the claims process and wasn't just acting as counsel. So you got to be careful about that. That's why I always say, don't make me sign the disclaimer. I want to be your lawyer. I don't want to be your witness. I'm not working for your claims department. I'm outside counsel. This may go back, by the way, to the poll question. The second pet peeve I have is when insurance companies say, what should I set for a reserve? This is more a liability question. Please don't ask me to set reserves. You all have your own reserving philosophies. Some of you may be conservative. Some of you may be have different ways you set reserves. When you assign me as defense counsel, I don't actually represent you. Ethically, my duty is to the insured. What's the reserve should be? Well, to protect my client, set it at the policy limit because I got to protect you from bad faith and I got to make sure there's no excess verdict. What you can ask me, what's jury verdict potential? What do I think the claim is worth? If it's a hit in the rear, jury verdict potential may be your reserve value. It's a little different question. You know, it's my job I always felt it was my job on a defense case. I'm the eyes and ears of the claim department. I'm supposed to give you the information you need to properly evaluate the case. But the ultimate question is what the reserve should be. That's your internal decision. That's just, I've had this argument with claim departments over the years, haven't always won, but this is my opportunity to make my case. Getting back to applications. Where are you going to see problems a lot of times? A lot of times I see it in usage. If you think about a homeowner's policy, the homeowner's policy covers the residential premises. And a lot of times people may sell the house. They may inherit the house, move elsewhere. Then they get a claim, but technically they're not living there. And there's some case law. I know you're coming from different states, so I'm not going to try and avoid individual cases, but I know there's some case law in New York where if you're not living there, but you keep your HO3 in place, you've lost your coverage because it's not your residential premises. Other areas we see are property under construction. You buy a new house. You want to have it painted. You want to do some minor touch-ups. You're going to move in within a month. That's probably fine. But if you're going to buy a house and completely gut the kitchen and you're not going to move in and redo all the bathrooms and you're not moving in for 4 months, that's technically a house under construction, and then it's vacant and it's more subject to a loss. Maybe that should be under a builder's risk and not a homeowner's policy. One of the questions on your application is always, is the property under construction? That's one I've seen a few times where the property, in fact, is under construction. There's a legitimate basis for saying, this is not the risk that we intended to insure. Obviously, on a liability side, what kind of dogs do you have, trampolines, that kind of stuff. Now, one of the issues on an application misrepresentation is when did the company learn about the misrepresentation? Did you do an underwriting inspection? You have cases where they lied about the occupancy. They had apartments in the basement they didn't tell anybody about, but your underwriting inspector went in there and made a note about it. And you let it pass. You kept the policy in place. Then all of a sudden, one of the tenants causes a loss and you want to claim a misrep, but you knew about it and let it go based on the underwriting inspection. So if you have a misrepresentation, make sure you're checking your underwriting file and checking to see what the underwriting inspection said. And was there a basis that you could have figured out that you had a problem? If you do discover the problem, then you got a choice to make. If the risk isn't what you thought it was, you all have cancellation, whatever the state is, 60, 90 days, you have to send out a notice of cancellation. This loss is not accepted to our underwriting. The problem with that is that from the time up until the date of cancellation, even though this is not an acceptable risk, because you had a cancellation, the policy stays in place up until the time of the cancellation. I mean, obviously, if you find out about it and the loss is immediately, you're not going to cancel the policy. You're going to rescind the policy. It's basically saying this policy should be void from day one. So think about the difference between cancellation and rescission and what risk you're accepting during the period of time up until cancellation. You also all going to have mortgagee clauses. So a lot of the times you find problems with the cases, you're going to end up paying a lot of the claim anyway, because you owe it to the mortgagee. Yes, you can take an assignment of the mortgage, but if the insureds are creating a lot of red flags, it's maybe because they don't have the financial assets to cover it anyway. A lot of times what you're trying to protect against, you can protect against the contents claim, you're going to protect against the ALE. But when you're thinking about these decisions, you got the issue with the mortgagee clause, unless the mortgagee had a reason to know that there was a problem. A case we see a lot of as we're coming to the winter season, water losses, freeze-up losses. And a lot of them I see is people go to Florida for 6 months. They're a retired couple. They spend 6 months in the Orient. That was actually a case I had. They're supposed to maintain heat. Your policy, a lot of these policies are going to say if the property is vacant for more than 30 days, you got to maintain heat to a certain degree, and they all swear they've maintained the heat, or that their first cousin was coming over and looking once a week, checking up, or the boiler malfunction, they didn't know about it. When you get those claims, a lot of times the key is going to be the utility bills. Those are things you can ask for, either through a EUO or your investigator can ask for it. If they don't want to give it to you, then you remind them that there's a cooperation clause in the policy. A lot of times what we find in these utilities is there's no oil usage if it's oil heat. The gas bill is like $2 for a 3,000 square foot house. Obviously, they weren't keeping the heat up, and those utility bills can help tell the story. Then you find out a question about how common it is for a mortgagee to be aware of a problem that might lead to a claim. I had some cases in Brooklyn a while ago, Brighton Beach or Brighton Beach area, Sheepshead Bay, areas that were set up as beachfront communities, and you had these small cottages that were like, people live elsewhere and they'd go out to Brighton Beach for the summer in these little cottages. All of a sudden, Brooklyn gets bigger and that property becomes more valuable, and the vacant land becomes more valuable than the ramshackle cottage from 1920 is on it. So we had some cases where the houses were coming down, and then all of a sudden the mortgagee is claiming, well, we lost the value of our equity because there's no house on it. They want to get paid for the house. And we did have some argument that some of these mortgagees knew that the houses were coming down. They were insuring the property. They knew the houses were coming down. They knew or should have known that what they were insuring was basically vacant land. I mean, that's kind of a rare situation. This is one that comes to mind where the mortgagee was in a position to know that their equity was going away. If part of the mortgage is funding a construction loan, then they should know that there's a chance that they should be aware that there's a problem with the coverage. Going back to the water losses, a lot of times what you're going to see is when the water break happens, tremendous spike in water usage, which will give you, you can see the utility bills, the water usage starts perking up in February, and the snowbird claims, oh, the loss happened when I came back in April, and the water really wasn't running for 2 months. I've had policies that have protective safeguard endorsements. This one always scares me, that if you're going to be out of your house for 48 hours or 72 hours, you're supposed to turn off the water to the house. My daughter lives in Baltimore in a row house. She stays with me for 2 months, because of COVID or whatever. Turn off the water to the house. I'm a little skeptical about that because I have hot water heat. I don't want to lose my heat. But it is something, I'll see that a lot on a lot of shorefront properties that people really aren't there in the winter. What I don't often see is, even though it's the one that makes, it's what all the novels are about, are the arson fires. Very rare, not always easy to prove. It's fraud. It's a higher standard. Some of them have the trilogy that you got to prove fraud, motive, that they got to prove the financial hardship. It's a lot easier to prove a misrepresentation than actual outright fraud. I mean, I had one case, and I'll discuss it in a minute, where the carrier kept saying, we want to prove arson. I said, no, you're not going to win the case on arson. Go for the misrepresentation. It's a much better burden of proof. There was a case in Monroe where there was a very suspicious fire in the basement. Did I think it was arson? Yeah. Did the judge ultimately let the arson go to the jury? No. Got a fire in the basement. What am I going to look for? Sometimes you get accelerant. But a lot of times, why did the fire happen in the middle of a concrete floor? There's no obvious ignition sources there. So we didn't find an accelerant, but the whole circumstances of the fire were extremely suspicious. Red flag. Then you start digging into the financials. The mortgage hadn't been paid for several years. House is in foreclosure. Plaintiff had a very spotty work history. And then we get a contents list of like $500,000. When you get a large contents list, what you're going to look for are, does the person have the income to justify the contents? If they're working for Goldman Sachs and you get $1 million contents list, well, this guy has more money. His money to burn is probably buying a lot of toys. It's not going to be a red flag. If somebody's not making a lot of money and all of a sudden they have a large contents list, total red flag. This case went even more so because the public adjuster submitted a contents list and the plaintiff and the insured went through it and started raising the items. And that was a case that ultimately was tried on the issue that the money that she had didn't justify the contents list that she presented. And then we also had an issue that she had filed for bankruptcy. Now, I forget what the exact number is. Maybe it's $25,000, but when you file for bankruptcy, you can exempt a certain amount of potential of personal property from the creditors. When I confronted her with that, her answer was, well, this is what the lawyer told me to say. I have no doubt that's what the lawyer told her to say, but the lawyer was not going to admit that under oath. So I took his deposition and I actually subpoenaed him for trial. And he's not going to admit, I told her to put down $25,000 because that's the bankruptcy exemption. He said, I told her to give me an honest list. So I was able to point out that if that's an honest list, she's only got $25,000 worth of contents. At that point in time, where did the other hundreds of thousands of dollars of contents come from, including the $100,000 in window treatments on a house under foreclosure? There's nothing more dreadful in a trial than going through a contents list item by item. So I just picked out a highlight, like the 6 pair of Chanel shoes. Originally, there was 2 shoes and it went up to 6. And at one point during the trial, she had said that she did things to protect her kids and she wanted to feed her family. So I kind of pointed out to her, what does 6 pair of Chanel shoes got to do with feeding your kids? And her answer was, a woman needs her shoes. She didn't do very well. You can try cases. I suggest you pick and choose your battles carefully. You questionable cases, those are the ones you may want to compromise. You got a good case. And that was actually a case where we had offered her some money to go away. She figured this was her lottery ticket, did not want to go away. I'm checking my time. I had another case up in Rockland County. This was a totally legitimate fire. Large house, like 5,000 square feet. It was a rabbi, and he was refinishing the floor, and the contractors messed up. And the contractors had a $1 million policy, which is important because there's something called the make whole doctrine, which is if the tortfeasor does not have enough insurance to cover both the subrogation claim and the insured's uninsured claim, the insured's uninsured claim goes first over the subrogation claim. When we start digging into this guy, he submitted a contents, the building claim there was no argument about. But as far as the content, he submitted a contents claim of like $2 million. Like $1 million worth of artwork. He had 85 copies of the same prayer book. And we start digging into it. He's actually running a synagogue out of his house. He invites a matchmaking system. He's inviting single couples and tries to get them all in there for the weekend. He's got 50, 60 people in the house. He actually had part of the house had dormitory beds. So the issue is these prayer book, and he's fundraising off of this. So all these prayer books, are they for personal use or are they a business use subject to a $2,500 business use limitation in a policy? Then we started digging into the artwork. So I asked for his tax returns. Why do you want to see my tax returns? I'm interested, and by the way, you got to turn them over. This is really interesting. You've only declared $85,000 a year worth of income. You've got a 5,000 square foot house in Rockland County. Your carrying costs on the house are $50,000 between taxes and mortgage and utilities. And this is before we talk about the private school for your 6 kids. How are you buying all these paintings? Your contents list makes no sense. You don't have the income. So at one point he said, well, that's not all my other income. What's your other income? Oh, I have this other foundation. Oh, the foundation you're running out of your house, which means the business you're running out of your house. Then we start figuring out about the artwork. Well, it turns out that he had a lot of contacts with Israeli art galleries, and he had a lot of connections. So he would arrange for people in the US to buy paintings from these galleries in Israel. And because he was such a nice guy, the galleries would just give him paintings as a favor. Obviously, he was getting the paintings as a commission, and I kind of asked him, did you tell the IRS about the paintings that you were getting on commission? What ended up happening on that case is I had a heart-to-heart with his lawyer, and I said, do you really want me to keep digging, and which tax authority do you want me to notify? And we worked out a rule. And I'm going to go back to that $1 million policy and that make-whole doctrine. Theoretically, on his uninsured losses, he could have grabbed the entire $1 million. But we cut a deal that I actually got 60% of that $1 million in exchange for working out a settlement on the contents claim. When is it critical to litigate a claim? What is the point which a carrier has to litigate? I'll get to that. Make a note. When litigate? Well, the quick answer is when you've denied the claim and you get sued, then you don't have a choice. Then you got to put in an answer. But when going back to the rabbi case, I got around the make whole doctrine by working out a deal where I'd carry the ball on the sub-row, I'd get the lion's share of the money, and the contents claim was resolved. So it's one of the things to look at, and that's a red flag or excessive contents claims. And an excessive contents claim can be, you can get material misrepresentations in the presentation of the claim. The insured didn't tell you the truth as to how the loss happened. Again, excessive amount being claimed, especially in contents. Another example of when I litigated, by the way, this is where I actually sued the insured recently, was you have a limitation to sue clause in your policy that's 2 years. And we paid the ACV, and the insured didn't do anything for almost 2 years. And then like a week before the 2 years was going to come up, they submitted a new building claim for like twice what had already been agreed to. So we let the week pass, and then I sued the insured for a declaration that they were not entitled to make any further claim because the limitation of suit clause barred any action. When to litigate? Do you want to play offense or defense? You play offense, you can pick the venue. It's usually something you're going to, that's where counsel becomes useful because we can consider the considerations. Sometimes you're going to get involved in appraisal issues. You may want to go to appraisal because you're just never going to get it solved. I don't think there's any hard and fast reason. If you deny a claim that the insured's got a lawyer and a public adjuster, you may expect a summons and complaint in the mail. The next thing I want to talk about in terms of claims is the concept of actual cash value versus replacement cost value, which is something I'm not going to go into the details. I'm sure you all know what it is. And truthfully, I've always considered the concept of replacement cost holdback as some sort of an artificial number. You guys are obviously holding back some money because the insured has to, otherwise the insured gets a windfall. If the guy's got a shack and the replacement cost is worth double the shack to rebuild it, obviously he gives them the wrong incentives, and that's why they have to actually spend the money before they get the replacement cost. But you can make the insured actually prove the replacement cost. I had a fight early in COVID, legitimate loss, but the insured signed a proceeds contract with Paul Davis, or the Paul Davis franchise for Brooklyn. And the proceeds contract said he's going to get whatever the insurance company is going to pay. And they put it down for an inflated amount. And the insurance attorney took the position, well, we're committed to that amount of money. So you just got to give us the replacement cost because we've incurred the money. I said, not so fast. I know the house was rebuilt. That was another issue. The house ended up getting rebuilt past the 2 years limitation. That is not going to be a successful argument. If the argument is about a replacement cost where the insured's actually doing the work, you're not going to be successful saying that they didn't bring suit within 2 years and deny the replacement cost. That's not to me. I asked for Paul Davis, who operates through subcontractors. I said, give me your subcontractors' invoices. Why? I want to know how much was actually spent in rebuilding the house. So we learned, first of all, that there were betterments and improvements. They put in central air conditioning they didn't have before. I said, that doesn't count for replacement cost because that's a betterment and improvement. That's on your dime. There had actually been an appraisal proceeding where they convinced the appraiser that they were entitled to $40,000 for plaster walls. Except they didn't put in plaster, they put in sheetrock at half the price. But when I went through all the subcontractor invoices, and even including an allowance for overhead and profit, which is a general contractor they'd be entitled to, and as well as some time for their laborers, it came in for far short of what they were claiming, and certainly less than the proceeds contract. The insurance attorney told me I was wrong. Then his motion for summary judgment was denied. And then the claim ended up getting resolved for less than they were looking for. I told my insurance company, you got to pay something on replacement costs because they clearly did the work. And they are entitled to overhead and profit. That was a case we were able to compromise. But that was a case where we made them prove, yes, you've actually spent the money that you've done. Okay.
We did have a couple other questions too.
Yeah. Well, before I get to the next case, other questions?
All right. Are lawyers willing to work with the actuaries to exchange ideas on the reserve, or is that a total no?
I wouldn't say no. And I haven't always, ultimately you guys are the client. And if you want me to tell you what to reserve the case at, I don't have a choice. Yes, well, I'll work with your actuaries, but you're kind of, if I was good at math, maybe I would have got into finance, not insurance defense work. I could have kind of go work for Goldman Sachs. What I can tell you is that what I think the jury verdict that value is. What do I think the range is? Which, it's the information you need to set a reserve. If your reserve is basically what your exposure, I can tell you what your exposure is. I just don't like putting down, this is what you should reserve the case at, because that's based upon internal company decisions. What to tell the public adjuster? Depends on the public adjuster. I mean, look, some of the public adjusters may have very good relationships with your with your field adjusters, and they can work together. Ultimately, if you go into litigation, your claim file is discoverable other than attorney-client privilege. The insured in a first-party litigation is going to see your claim notes. Be careful what you put down. It may come back to bite you. And I've actually taken the position, by the way, and had some success with it, that reserve information is privileged and not subject to discovery. Could be, like on a first-party claim, reserve information does not necessarily equate to the actual value. Sometimes you're going to settle for more than reserve, sometimes less. Reserve information is just a estimate, and it's a regulatory requirement. So I really object to reserve information defining value on a case. Okay. The case I have in Long Branch, New Jersey. Case that had a little bit of everything and went up to the appellate division 3 times, and it's got a lot of issues relevant to claim handling. In the late 1800s, Long Branch New Jersey, on the Jersey Shore, Monmouth County, was the place to be. There's a park there called Seven Presidents Beach, County Park. And it's called Seven Presidents Beach because 7 presidents spent their summers there in the late 1800s. Actually, after James Garfield was shot in the back by a disgruntled office seeker in 1881, he was taken to Long Branch. James Garfield actually died in Long Branch, New Jersey. And it wasn't actually the bullet that killed him. It's because they didn't know enough medicine, and it was all the doctors poking in him, trying to get to it that caused an infection. So you're right on the shore. And in 1910, 1920s, there was a whole bunch of big shorefront houses built along the beach. Then it kind of become dilapidated. Long Branch, which is now very upscale, went through some tough times in the 80s and 90s. And in the 1990s, Monmouth County said, you know what, we're going to tear down all these old houses and we're going to make a really nice beach, county park beach right there in Long Branch. 7 Presidents Beach, one of my personal favorites. There was a local electrician who was politically connected who got wind of the county's plans. And he bought up all these houses in the names of his friends and shell corporations. And his plan was, when you have a condemnation, the value of a property is highest and best use. And his theory was highest and best use is that all these properties have condominium approvals. So I want you to value the land as if I could develop a condominium on it. All sorts of litigation on it, collateral to our case. But he didn't ultimately succeed because the appellate division ruled that just because you theoretically could get condominium approval doesn't establish value. In order to get it, you would have already had to have had the approvals, which of course the planning board was never going to give them because they were turning the property into a beach. But this brings us to our case. One of the other things he did in order to build up the value of these houses was to theoretically invest a lot of money into renovating them and bringing them up to speed. And when we ultimately got the invoices, there was a lot of kitchen equipment, golf clubs. He's an electrician. There was enough electrical light bulbs to light up the city of Long Branch, as well as many, many golf balls. And one of the things that troubled me throughout this case is I could never figure out what use the golf balls had in renovating these houses or how it increased the value. The company involved did not write shorefront property. This electrician had an insurance agent who was of, let's say, questionable ethics, who issued a binder for this house. Kind of forgot to send the binder up to the underwriting department. Shortly thereafter, the house burns down. We couldn't prove it was suspicious. And the claim gets reported to the claim department. And the claim department is very confused because they can't find the policy. Red flags all over the place, and that's why this thing was litigated for 8 years and ended up in the appellate division 3 times. So part of the fight was this a valid binder? Because clearly he did not have authority to do that. But he did have binding authority. So you get into the concept of apparent authority. You have given this person authority to act on your behalf. If the insured didn't know he didn't have the authority to bind the policy, then you're going to be stuck with it, even though the agent acted outside the scope. Apparent authority is something that'll come up in a lot of areas, but it's usually, if you give the, you have agents, you give them authority, people rely on that authority, that's going to come back to hurt you, even if they act outside the scope, unless they know they're acting outside the scope. Now, the other thing we had done during the claims process is we were fighting about value. Oh, by the way, they also tried bringing up consumer fraud. I know it's different in different states, but in New Jersey, at least, the Consumer Fraud Act does not apply to the claims process. It can apply to the underwriting, but not the claims. But what we did is we took it to appraisal. to establish actual cash value. And the appraiser wasn't too impressed with the golf balls. So we actually got a favorable actual cash value number. Now, one of the things the insured complained about, their argument was, well, we were not allowed to go to appraisal because we had denied the existence of the policy in the first place. Therefore, their position was all policy terms disappeared. The trial court disagreed. The first time we showed up for trial, we showed up before the judge, and the judge couldn't figure out whether it was jury or non-jury. Now, usually trial judges get very upset when you call up the appellate division and say the judge is making a mistake, I want an immediate appeal. In this case, the trial judge, when we came back after lunch, he initiated the interlocutory appeal. He called the appellate division and said to the appellate judge, I don't know what to do. Why don't we issue a stay on the case and these guys can appeal it? The only time in my life I'm ever going to have a judge asking us to appeal one of his decisions. So we went up to the appellate division, and the appellate division decided it's a jury trial. You are not entitled to a jury trial in every instance. Without getting into making political judgments, there's a certain case going on in New York where equitable relief is being asked for, where there is no entitlement to a jury trial. The Constitution says you're entitled to a jury trial in an action at law. And the distinction between an action at law and an action in equity is an old English distinction that goes back hundreds and hundreds of years, when England actually had separate law courts and separate equity courts. And we adopted English law when we did the Constitution. And an action at law is an action for money damages, primarily. You know, personal injury cases, looking for damages. An action on an insurance contract is an action for money damages. They're looking for the benefits under the policy. They're looking for money. So those are actions at law. So this case was actually decided to be a jury trial. It may be different if it's a declaratory judgment and the issue is there a duty to defend? Well, then you're asking the judge to make a declaration. That's probably equitable, non-jury. What I'm about to say may be slightly counter. Proper investigation can save insurers money. The answer to that question better be true. Getting the case to the insurance defense counsel early on, my vote is that saves insurance companies money as well, but you may all disagree. Where I'm going to be counterintuitive is I think insurance companies are unduly afraid of jurors. I think you should be as afraid as judges as jurors. And jury trials and non-jury trials try very different. Non-jury trials, they're a lot looser. When a judge has got a jury, he's going to play it a lot stricter and by the rules. And either way, if the judge in a non-jury trial makes findings of fact, you're not going to beat that on appeal. And a lot of judges don't like insurance companies. So don't necessarily think the judge is going to give you that one judge is going to give you a better shake than 6 jurors. Obviously, pick and choose the cases you have. But if you've got a decent case, like my woman with $100,000 in window treatments and 6 pairs of Chanel shoes, the jury's not going to like it. You can win this case. If you have an obvious arson case where the insured clearly did it, you may actually do better in front of a jury than a non-jury. You know, when I try a case in front of a jury, I just make sure I'm representing a mutual insurance company. We don't sell health insurance. I don't like health insurers either. So don't take out the fact you're mad at your health insurer against my property and casualty insurance company. And I also always ask them the question, you know, during jury selection is, who likes to pay their insurance premiums? Nobody does. Well, you know, if you sanction fraud, you're going to end up paying more in premiums. No, I can't say that, but there's ways of implying. We went back for trial number 2. And this one turned on the apparent agency issue, and that one we lost, as we probably should have. The judge then declared you're entitled to the appraisal award. They wanted replacement cost. Remember, you can't get replacement cost if you didn't rebuild. They never rebuilt the house, and the judge said you don't get replacement cost. So we went up to the appellate division, case number 2. And the appellate division, first of all, ruled that appraisal was perfectly appropriate. The fact that we were fighting over the existence of the contract didn't mean the other contract terms all went away. So the appraisal stood. They sent it back for another trial, though, because the issue was, and there is case law to this in multiple states, that if the insurance company does something that prevents rebuilding, then you can't argue that the insured didn't rebuild. If you don't pay actual cash value and the insured runs out of money and can't rebuild, and then it turns out you should have paid actual cash value, well, it was your failure to do what you were supposed to do that prevented rebuilding. You may end up being stuck paying replacement cost as well. I'm a big believer, by the way, in paying undisputed amounts. If you pay an undisputed amount, you've acted in good faith, you put your cards on the table, you're doing what you're supposed to do, it makes you feel better, look better, and you also the more you can limit the amount in dispute, the easier it is to resolve the case. So we went back, pretty good. We went back to try the case on whether we prevented them from rebuilding. And they had a friend who was the building inspector, and they had all they had an after the fact building permit, and they were going to argue that they were going to rebuild. Except the guy admitted on the stand on cross-examination that when I got him to admit that County of Monmouth was condemning the property. That you couldn't give a building permit on property that was being condemned. So the real reason they didn't rebuild had nothing to do with us. It had to do with the fact that the property was being condemned, which was the whole point of the scheme in the first place, which was to make money off the condemnation. So that was one reason why we won the case the second time. But there was multiple questions asked to the jury. And one of them was, did the insured commit material misrepresentations in the presentation of the claim? And the insured had a very tough time explaining on the stand what role golf balls had to play in rebuilding and renovating the house. And the jury wasn't too fond of the golf ball, so they also found that there was a misrepresentation in the presentation of the claim that ended up being upheld on appeal. I want to leave you with something that a wise old claims manager told me. And that's sometimes when you have a legitimate coverage issue, you're acting in good faith, you're raising something legitimate. But, you know, there could be some things going both ways. He said to me, Rick, don't think about how much money you're paying on this claim. Think about how much money you are saving off a claim you otherwise would have paid if you didn't have these coverage issues. And I always thought that was a good way to look at a lot of these claims. You're not in bad faith. You're negotiating the resolution of a disputed claim. So it's not what you're paying. It's you've raised legitimate issues. You may be in suit. We're settling the claim. Nobody's admitting to any fault. And what have you saved by raising legitimate coverage issues? I know we've covered a lot of ground here, but I guess the lessons are pick and choose your fights. Most claims are going to get resolved. A lot of it is just you going back and forth with the public adjuster. You're ultimately going to come up to a decision. Some claims just become headaches, and you're going to pay X amount of dollars to get rid of them. And what you're really looking for are those red flags, because once you start seeing one red flag, there may be multiple red flags. And those are the claims that you're really going to dig into. So did I go long enough? Did I cover it?
Yeah, Sue, you're muted. First, I want to say thank you so much. I found it really interesting to hear, especially the case specifics. There's a lot of real bad facts make tough decisions, for sure. So the question around when to litigate, I guess I'd still, ask you that, where you think where there are situations where I know I've heard people say it's a matter of principle, but really where you just know that there's going to be litigation and you feel you have to.
Look, we're in the money business. We're in the risk business. We're in the risk minimization business. Principle, principals don't have a lot to play.
I would agree, but
I don't think litigating on principle, I mean, if you've got a particular public adjuster or a particular public adjuster attorney, and it's just time after time after time, maybe you have to put your foot down. But a lot of times you're not making the choice to litigate. A lot of times you're being forced into litigation.
Yeah.
And the one thing I didn't want to talk about, and that's a whole different discussion for another day. And the other thing you got to be careful of, depending on what state you are, Florida, Pennsylvania, is bad faith. The bad faith rules are very different, and you're gonna, you got to be careful about where you stand. New York's not a great bad faith state. New Jersey, there's protections for the insurance carriers other than underinsured motorist claims. And the reason why you lost your protection on underinsured motorist claims is because the president of the New Jersey State Senate is a plaintiff's lawyer specializing in auto claims. And he got tired of certain auto companies. You got a $25,000 uninsured motorist claim that's clearly worth it, and they're fighting it tooth and nail. And I actually thought he had a legitimate basis. But when that bill came up, they were actually going to make it much broader in terms of bad faith, and it really just got limited to auto claims. So New Jersey's not a strongest bad faith claim. That's another issue, and that's another issue you may have to take into account depending on your jurisdiction and what the facts are. What's your bad faith exposure? But I don't think there's any hard and fast rule, and I think every case is really case specific.
Rick, thank you so much for this presentation, because it was really good. So,
all right, I got an important question to ask. You guys going to send me certifications for my CLE?
Sue, I turned to Sue for.
we can't afford to offer CLE classes.
Oh, okay. All right. Then I
But
did
we appreciate
Yes.
appreciate you stepping in.
I did
at
a
the
pro
last
bono
minute
and
to do
I'm
it.
glad to have spoken with y'all.
Yes,
All right, take care.
we appreciate it. Thank
Take
you.
care. Bye-bye.
Thanks. Sue,
This
any last comments?
concludes day 2 of our educational seminar. Once again, we thank our generous sponsors as well as all the attendees and the MSO team. Remember, it's never too early to offer suggestions for future webinars and presentations, or for articles, for ed seminars. We're open to all kinds of information. Please check out our library of nearly 200 articles on our website. Check out our new YouTube channel. And thank you again for coming. And thank you to New England Excess Exchange for letting me do my presentation from here today instead of my hotel room. And the CE credits will be booked in the next couple days. If you have any questions, reach out to me, and have a great rest of your day.